Please be seated. We'll hear argument in case number 240879, in re LaPuerta.
May it please the court, Ms. Robertson will present argument for the relators. Relators have reserved 5 minutes for rebuttal.
Good morning. May it please the court. I'm Michelle Robertson. I represent the relators, Dr. Leo LaPuerta and his PA, and we're here today asking the court to respectfully grant us mandamus relief from an improper order granting a new trial after a jury trial in a medical malpractice case that resulted in a defense verdict. So just as a little bit of a setup, during the trial, the respondent decided that it was proper to submit a loss of chance instruction in this case, which involved a terrible bandsaw injury, and ultimately the patient lost his entire finger. And we asked the judge to submit a loss of chance instruction, and the judge agreed to submit it, and it tracked the wording of the instruction that this court had already approved in Columbia v. Hawley. Then we had the trial. During deliberations, the jury came out and had a note and asked for a clarification of what the word finger meant in the instruction. So after that happened, the judge decided not to give them any modified instructions. The jury returned a defense verdict answering no both to Dr. LaPuerta and Mr. Torres, and the court rendered a take-nothing judgment. Then after that, the plaintiff filed a motion for new trial, and the judge changed her mind and decided that it was error to submit the loss of chance instruction, and that was harmful error, and so she granted a new trial.
So what do you think finger, if an answer had been given to the jury's question, what would have been the correct answer?
I don't think there is a correct answer, and I honestly think it's a fact question, because if you read the testimony.
Well, part of his finger was already gone at that point, right?
Mm-hmm.
Okay.
Mm-hmm.
So.
Well, actually, it was not gone completely. Part of the bone ultimately was lost, but if you see in the pictures, the finger's still there. It's trying to be healed because he refused. Every time he refused amputation.
What did you mean when you said it's a fact question? There's no correct answer to the question the jury sent the judge.
Because I think the testimony was conflicting on whether he was going to lose only a part of the finger or whether he was going to lose the whole finger. The plaintiff's theory was that he was only going to lose the part of the finger above the bandsaw injury, and the bottom of the finger was fine until Dr. LaPuerta allowed an infection to come in. But the defense experts, they didn't testify with any distinction between you're going to lose part of the finger or all the finger. They testified that because of the severity and the nature and where it happened and how far across it went, it's totally compromised circulation, and he was going to lose the finger regardless of whatever treatment Dr. LaPuerta tried to give him. So I personally, I have no idea what the judge was thinking, but I think that might be why the judge didn't offer a supplemental instruction. And at the time, the plaintiff did not ask the judge to submit any kind of clarification of the wording. And I believe Mr. Madani said he thought it meant the whole finger. So the judge listened to both sides and then said, I think I'm not going to change the instruction. I'm just going to tell him to go follow the instructions I've already given.
And both sides were okay with not answering the jury? Neither
side objected. So we're arguing to this court that this was a clear abuse of discretion, because the order that was ultimately signed, granting a new trial, the first order had no reasons. So we pursued getting a new order that had reasons. And the new order has 7 reasons, but they're very short. They don't have a lot of explanation. They don't refer to the evidence. And there's a lot of other problems with them, including that we think that some of them are just flat out not legally valid reasons to grant a new trial.
What are the extraordinary circumstances justifying mandamus here? I see your point that this new trial order has been issued and it's faulty, and it might lead to a pointless new trial and all that. But isn't that garden variety? Like I guess I'm just looking for what's the plus factor that gets mandamus relief here? Because
we've already gone through all the motions and steps to have our jury trial, exercise our right to take it to trial. And it was taken away for reasons that are not supported by Texas law or by the record.
But you could get vindicated on appeal, right?
Not me. That's the problem, is now I'm having to take the appellate review, whereas the plaintiff lost, so the plaintiff could have taken the appellate review. I can't appeal the order granting the new trial, so that's
But
one
ultimately, I
reason.
mean, if the judgment comes out against you on the second go-around, there's still appellate remedies, right?
For the second trial, but we have to go through the process of the second trial, and what the court's jurisprudence is on new trial orders has emphasized is like there's some constitutional boundaries here. Courts can't just substitute their judgment for a jury unless there's good reasons.
But if the jurors were confused, that's a reason. I mean, a lot of what we said is be specific. That's what Columbia is really about, you know. Be specific if you're going to grant it. And if there's confusion, isn't that a reason?
I don't agree that the order just says, the order doesn't even say confusion. The order says, in the harm finding, the court said, the court finds the instruction probably caused the rendition of an improper judgment based on the sole question asked by the jury in this matter, which requested clarification of what the instruction meant when it referenced the finger.
But what I got from that was that the instruction, which was referencing proximate cause, could be read to have been the definition of proximate cause in the question.
Well, the general definition was given also, just like the court said that needed to happen in Columbia v. Hawley. So, I mean.
And hence the confusion, I think, maybe.
No.
I don't know.
Maybe, but I mean, what I think is that the order doesn't contain the explanation that this court has most recently required to explain why was it confusing? There was.
Well,
If a charge has been, if it's unobjected to, it's been approved in case law, it's been used many, many times, can it ever be a valid ground for a new trial that there's a jury out there that didn't quite understand it?
I mean, that's certainly our position. I mean, we did everything we could to try to make sure we were following the law. We made sure our experts provided the evidence that needed to fit that Kramer definition about there being a less than 50% chance of the finger surviving the injury, regardless of what the doctor did. We do have that testimony. There was actually 3 theories in this case, unlike in Hawley, because the defense put on evidence that Mr. Torres was also negligent and that his negligence might have contributed to cause the amputation too.
there aren't many cases, right, applying this loss of a chance instruction outside the wrongful death context.
They're all death cases, but Your Honor,
Right,
Park
so
Place.
if we've approved it in a death case, obviously this instruction's not going to be confusing in a death case because you're either dead or you're not dead. You can't be only mostly dead. But if you're applying it to a finger, then it can be confusing about whether it's the whole finger or only part of the finger, depending on the facts. I'm sure we could come up with some other hypotheticals about, if you're applying this instruction to, some other sort of injury, it may matter the extent to which it could be remedied. And this instruction really doesn't address that one way or another. So I guess I'm struggling to see why the fact that we've approved it in a wrongful death context means that it could never be confusing in this context.
Well, Your Honor, it's not about the type of case where you've used it, because loss of chance goes to proximate cause. That's in every kind of case, every kind of medical malpractice case, whether it
Right,
involved
but
an
the question
injury.
is loss of a chance of survival of what? The partial finger or the whole finger?
But that was only part of the case. That was the plaintiff's theory of the case. That wasn't the defendant's theory of the case. They testified.
But you asked for the instruction. This
Right.
instruction, loss of chance, right?
Right, and they didn't object to it. They
Right.
didn't say it wasn't in substantially correct form. They didn't make that. All they said was it shouldn't be given at all. They didn't raise any complaint about the partial versus the whole till the jury asked the question.
So what do our cases say about that? If there's no objection by either side to the charge, and the jury comes up with a question that reveals to everyone that they're very confused for some reason that nobody anticipated, and the trial court just says, continue deliberating, I'm not going to answer your question. Do we have any cases that say it doesn't matter how confused the jury was because nobody objected to the charge, that can't be a ground for a new trial?
I mean, I didn't find a case that says it exactly like that, but I think what our complaint in this case is that the judge didn't explain, other than the question, why the instruction caused the jury to render an improper judgment. She didn't even say why it was an improper judgment, because there was plenty of evidence to support a judgment in favor of Dr. LaPuerta and even Torres. I mean, the jury answered no to both of them, meaning that they could have decided that the plaintiff just failed to meet a burden of proof, and Dr.
The idea is that juries often, along the way of their deliberations, send out notes, right? Because they're struggling in their deliberations to reach a verdict. But whatever struggle or confusion might have happened, at the end of the day, this jury didn't deadlock. They reached a verdict.
No, they came back
So whatever
11-1.
confusion they had,
They resolved.
so could a trial judge then say, well, because the verdict was precipitated with a note, that's cause to question the verdict?
I did not find any case that said the mere fact that the jury asks a question establishes harmful error. I think you have to look at the evidence in the case. And
It's been a while, but juries send out a note every other trial, maybe even more frequently than that.
Right, but the plaintiff even thought that the question is worded meant, the plaintiff's counsel.
No, I'm just saying that if that would be grounds for a new trial, that would be
It would happen all the time,
challenging.
yes. And it goes back, I guess, also to Rudolph, which Justice Young wrote that opinion and talked about how when you are saying something caused harmful error and it makes you reverse a duly deliberated verdict that was 11-1, there was one dissenting juror, the one that decided to send a letter in or whatever, and the court, that argument was abandoned after the first ruling, but the court needs to explain why. Why is this a wrong verdict? Are you saying that there could only have been a verdict for the plaintiff? Is that what you're saying? Because the evidence could have supported a verdict for the defendant without regard to the instruction. There was this, like the plaintiff was saying, this was just a straight medical negligence case and he shouldn't have given that instruction. Well, there was testimony that Dr. LaPuerta was not negligent. There was no infection in the finger on July 11th. And even if there was, the way that the cut and everything was, even him giving IV antibiotics wasn't going to prevent amputation. So what's wrong with the verdict? Like, how did that taint the verdict? Are you saying there could only be a verdict for the plaintiff? No, not under the evidence in this case. So that's why
we may need to provide some guidance in ruling, whether we rule for you or the other side, on what this instruction should say, so that people know in these types of cases, non-death cases, where you could have something, an injury to a body part that partially survives, and your answer that you gave earlier is that's a fact question, and I think that's hard for me to understand. So I know you have a lot of experience in this area, but why would it not have been correct to say you were instructed that Jose Torres's finger, in whole or part, must have had a greater than 50% chance of survival?
Well, that might have been better, but I think that's what it says.
Would it have been correct?
With the finger means in whole or in part, doesn't it? Just when it's unmodified?
Oh, well, maybe so. And so would it be okay to say in whole or in part? You wouldn't object if that were the instruction?
Well, I wasn't trial. I hate to say that for my answer. I wasn't trial counsel.
Not in this case, but in a future case involving a body part that could survive in part.
That's why I think it depends on the evidence, because that's what I was saying. The plaintiff's expert is the one who brought up this whole part of the finger was destined to be lost because of the cut. But the defense expert said the whole thing, because the artery goes up and down, and so because it was cut, the medicine can't get to anywhere where it's supposed to go. And so that's why the defense experts talked about the finger. So there was both. That's why I think it was a fact issue in this case, and that was probably why the judge did not specify. Now, maybe it would have been fine to say in whole or in part, just so they could consider both. But I don't. But nobody asked her to do that. Nobody.
I understand in this case. I'm
Yeah.
just trying to figure out what the right answer is, because
Right.
people are going to read this case and other cases and try to
Correct.
figure out what should this instruction say, and we need
Right.
to provide we may need to provide some guidance on
Well,
it.
that's what I was gonna. So I have the two instructions. I was gonna look at the one from Holly. So it just says, in Hawley, it said she must have had a greater than 50% chance of survival, whereas in this case, it says the finger must have had a greater than 50% chance of survival, and that's only because of the nature of the
Yeah, it was a
type of
death case, right.
Right. But I mean, unfortunately, I mean, there is an injury case, and it's Park Place v. Milo, but it was a summary judgment case, so there
was no jury charge.
There was no jury charge. But in that case, that started out with a surgical injury that went south, and then it was about whether a doctor who tried to wean her off the ventilator could have caused the death. And there was, in that case, uncontroverted expert testimony that there was only a 40% chance at the time of that doctor's negligence that she was going to survive the original surgical injury. So the court said, yeah, that negates causation as a matter of law. So I don't know why that doctrine wouldn't apply any time that you have a case where the plaintiff has the burden to prove proximate cause. I don't think it matters what kind of case it is.
Any further questions? Thank you, counsel.
Thank you, Your Honors.
We'll hear from the real party.
May it please the court, Ms. Tippett will present argument for the real party in interest.
Chief Justice, may it please the court. We're here today at Relator's invitation to you to expand the lost chance of survival instruction further than it's ever been expanded before. We agree that a jury charge or a jury verdict should not be disturbed lightly. However, when a verdict is, trial judges, as Justice Young mentioned in his writing for the majority in the Rudolph case, said that trial judges actually attend the trial and are best suited to evaluate its deficiencies. And when a verdict is irredeemably tainted, a court's willingness to subject itself to the burdens of a retrial is commendable. Here, the jury, we agree, the jury very well could have found that Dr. LaPuerta was not negligent. Or on the other hand, the jury could have found that Mr. Jose Torres, the real party in interest, was in fact negligent that caused his damages. But in this case, the jury was presented with an instruction that had to be basically massaged to fit the facts of this case. So it's our position that not only should...
But there was no objection to the instruction.
There was an objection to the instruction.
Pardon?
There was, in fact, an objection to the instruction.
On that basis?
The objection to the instruction was that the specific objection was not the right instruction for this case. And so it's basically, how I've looked at it in digesting it, it's all about whether or not this is the right instruction, it's the right fit for the case. And it's not...
But the whole or part issue wasn't aired out at the charge conference?
No, not at that time. But when you look at the judge's actual order, I submit to you that all of the respondent's reasons are her trying to say in different ways that this is not the right fit for the case.
And when you say that, expand on what you mean by it's not the right fit. It's not the right fit because it's not a death case? Is that a categorical rule then that you would put on this instruction? It's available only in death cases?
Justice Huddle, I think that that could be how this court interprets that this instruction should only be used in terms of death cases, and certainly that is what the jurisprudence seems to lend itself to. But even if this court decided that to expand it beyond just death cases, it doesn't fit the facts of this case because, as my opposing counsel even acknowledged, there was testimony conflicting as to whether or not Mr. Torres would lose the whole or the part of the finger.
Was that adequately explained in the order granting the new trial?
Yes. The order...
So what is your response to your friend on the other side saying that it was just global?
Okay.
Can
I ask clarification on your question?
Just what was the specificity that was set out in the order?
Okay. The judge gave several reasons why the instruction was improper. and I don't want to summarize them. I want to go straight to them, so if you'll bear with me. But, essentially, and I actually don't agree with the respondents' reasons 2 and 3, where she cites Kramer, just basically say that this court doesn't, or Texas does not recognize the doctrine of lost chance of survival. I think that's Kramer, and that's not what we're dealing with here, which is the proximate cause instruction. But all the rest, in number 4, when the respondent cites the fact that the juror sent out the note, that is essentially saying there's confusion, although the word confusion wasn't there. But that is clearly the point that is trying to be made.
I took 4 as sort of summarizing the consequences of 2 and 3. Like we have this doctrine, which I tried to give an instruction on. Texas Supreme Court rejects it. That's not part of Texas law, and therefore the jury comes back and they ask about this thing. The instruction include the finger. That instruction was the very thing that Texas law doesn't allow. Paragraphs 2 and 3 of the new order. But if paragraphs 2 and 3 are wrong, and they are surely, then isn't 4 wrong?
Oh, absolutely not. And that's certainly, I didn't think about looking at it as that way, and certainly we can't get into the respondent's head on that. But when she does mention the fact that this jury instruction came out, or the fact that the jury question came out asking, are we talking about a whole, or are we talking about a part of a finger? She uses words such as, this probably caused the rendition of an improper judgment.
But why did it? Because if the jury ultimately reached a verdict,
Yes.
indicating that at least 11 resolved what confusion they had, why was the instruction harmful? If it is inappropriate to have given it in a other than death case, why was it harmful in this case, where there was sort of, the issue of, did the bandsaw injury cause the amputation, or did some negligence cause it?
Justice Bland, I don't think we can just assume that the jury resolved all confusion. They asked for clarification. They were denied that clarification, right or wrong. And so they did the best they could.
So I'll ask you the same question. Does this mean that any time that a jury asks a question and the judge gives the typical response, which is, please continue with your deliberations, is that going to be a basis for a new trial?
Certainly not.
Okay, and why is it different in this case?
It's different in this case because of the evidence. And the evidence was that there was an injury from P2 and 3, and this might have been a foregone conclusion to be lost. But it's a new injury when you now take this part and the metacarpal bone too. If I might just take a minute, as Dr. Henry testified as regards to the diagram of the hand, we have 3 phalanxes. And we start with one closest to the body, like I'm number 1, so 1, P2, and P3, and then the metacarpal bone. And this jury was given lots of testimony about the finger in general from the defense side, but on the plaintiff's experts, Dr. Henry, who was the treating surgeon who ended up doing the whole ray resection. The ray would be the entire part. And then the testimony from plaintiff's expert, hand surgeon, plastic hand surgeon, Dr. Robeson, there was evidence developed that that it was a different kind of injury, is a new injury. They testified that the bone here was basically, when Dr. Henry went in to touch it, it crumbled. At that point, they were linked it to the negligence in treating the P2 and P3. And so I want to circle back to your question, Justice Bland, is when the jury is being presented, they're in deliberations, they're giving no advice, but they do have an instruction that talks about a finger when they've already heard evidence that's really distinguishing the level of disfigurement, then that just is inherent confusion. And What the risk here is if we.
But you knew that at the charge conference. I mean, you knew what the evidence was, and you could have said, well, this, I'd like to suggest that we say, what do you think it should have said?
I don't think that you could have rewritten this to make sense.
If some instruction on lost chance were submitted, though, what should it have said?
Well, okay, I can't answer that because that presumes that the injury is just the top two, the end phalanxes, the P2 and P3. I submit that there's more than one injury here because this could be considered an injury, but this can also be considered an injury. And to take it all as one would be the same thing as saying any amount of disfigurement should have decreased to here. Maybe they had to take the hand or the arm. I mean, the fingers are part of the arm. You know what I'm saying? It's like you can it's a runaway train.
Would it have solved that if the instruction had said that the finger in whole or part must have had a greater than 50% chance of survival, because that allows the jury then to decide if it was this or this?
No, I think it would cause the equal amount of confusion, because now they're saying, why does it say in whole or in part? We agree that the top was a foregone conclusion. Mr. Torr's going to lose. He's going to have a half an amputation, but what do we do with the fact that it went so deep to the next digit? And there was evidence.
So it should have said you're instructed that a part of the finger must have had a greater than 50% chance of survival?
No, I'll clarify. Our position is that there should have been no instruction of this nature there.
Right, but assuming one is given.
That's it. You're going to make me say something.
Is this another double fraction case, Counselor?
Oh, you've lost me.
It was earlier this week, sorry.
Thank you.
We're not asking you to give up your case.
Thank you. I mean, I cannot think of an instruction that it would have not injected error into this charge. And that, in fact, just goes right back to the whole point, is that it wasn't the right fit for this particular case.
But doesn't the law say that you have to be confident that whatever the adverse consequence was more likely than not would not have happened but for the negligence? And so if you don't have something like that, that seems like you're getting right back into all of the cases now 30 years old, Kramer onward, that try to solve that problem.
Well, certainly, Justice Young, you're asking me if there's a problem in medical malpractice cases when we just use the PJC version of the proximate cause definition?
Well, here's what, Kramer says, your objections to this were primarily based on it just being about death. But Kramer says that there's no liability for negligent treatment that decreases a patient's chance of avoiding death or other medical conditions in cases where the adverse result probably would have occurred anyway. And so, I suppose the question I'm asking is it enough to just use the regular proximate cause? We've rejected that in other contexts. We said, no, that's too much to ask a jury to get from the regular proximate cause instruction this principle, and so we need to express it. Why would that not equally apply here? Which just means that the question Justice Busby is asking you strikes me as sensible, because we have to find some way of maybe tailoring it to the facts of the case, but just saying, well, it's just too complicated, skip it. That maybe is more a situation where juries need clear guidance, not less.
I agree, Justice Young, in the context, this court discussed that in Hawley, where it is just too complicated, but that's in a death case. And you're asking is it just too complicated for a jury when it's not a death case?
Kramer, I just quoted you from Kramer, which seems to be recognizing what strikes me as sensible, and that is there's a continuum, and if you're suing about something that's not quite death but is still an adverse medical consequence, the same principle applies. You just have to make sure the jury understands what it is.
So the issue for this court, though, is how do you extend this lost chance of survival instruction in a way that helps the trial courts know when it does apply and when it doesn't apply? If we're confused because we're talking about it so much here, imagine the struggle in the trial courts to figure out how to apply this if we keep expanding it beyond death.
Well, that's why I asked you the question about what it should say. And Justice Young's point about Kramer, I think, is helpful because the focus there is the adverse result. So what particularly, and maybe there's more than one, and that's why we got to confusion, but is the loss of the entire finger the adverse result that you're complaining about as a result of the negligence, or the loss of the partial finger?
The loss, it's all of the injuries is the adverse result. It's the disfigurement.
Well, I mean, it's presumably not whatever damage was inflicted by the bandsaw.
Certainly.
Okay.
Of course. That's not Dr. LaPuerta's
Right,
fault.
right.
And, Mr. Torres asked Dr. LaPuerta, can you save the finger? I can't think anybody would object to, you might think that that's a very reasonable thing to ask. And Dr. LaPuerta said, I don't know, I will try. And he couldn't, but then that's where this case is different, is because Dr. LaPuerta then did things that caused an additional injury, the exacerbation of the disfigurement. I look at this and comparing this in my own mind to, for instance, I got stabbed in the eye with a stick, and I go to an ophthalmologist and I say, doctor, can you help me? And the doctor says, I don't know, I'll try to save the eye. So the doctor pulls the stick out, but the eye can't be saved. But also, during my treatment, the ophthalmologist did some stuff, and now I've lost my orbital bone. And I'm really disfigured a lot more than if I just had an eye, where I could have a replacement of a glass eye. Like, my injury is bigger. My damage, the loss is, my harm is more than what I went in there with. And, and then
So is that the thing then, the exacerbation of the disfigurement? Is that the thing that the jury would need to be confident was a greater than 50% chance would not have happened but for the medical negligence?
That is true.
So that doesn't sound that hard to come up with some way. You have to talk about what it is that you're saying that the claim is. It's this collection of things, some of which the jury might accept or not, but whatever the jury thinks was caused by the negligence, was that result more than 50% caused, would not have happened but for the negligence?
Correct. But then, as you know, other trial courts are using your opinions to try to apply it to a new set of circumstances. And I have thought about the concern in diabetic patients who have foot neuropathy and they have wounds. And a lot of diabetic patients end up having to have amputated feet. And how do you go in there and say, well, apply this 50% loss of chance doctrine to that when there's so many factors that play into whether or not your wound is going to heal, your comorbidities. And so then how does this opinion that you give today on crafting a new instruction help in that case? It doesn't. So that's the struggle here. It's what you say it needs to be applied in all kinds of different cases. And by the relators asking you to expand this lost chance instruction beyond where it's ever been, it just creates more confusion. It creates the lines become more amorphous the further we go out. Where if we just rein it back in, say what we said in Hawley is what we mean now. And in these cases of death, or in that case, the patient was just about to die, then this lost chance of survival makes sense.
Should we be comfortable with the concept of a juror coming back after the trial and talking to counsel about what went on behind closed doors? And I'm not accusing you of anything. I'm just as conceptually, should we be comfortable with that having happened and just sort of let that pass as usual or acceptable?
Justice Blacklock, are you asking just whether I thought that shouldn't have happened or that has an impact on this appeal?
That's how we got here, right? Is my understanding is that a juror reached out and was upset about the way things had gone, and that generated the evidence or testimony that you needed for your new trial motion. And so then they get to interview the other jurors? Do we have depositions of the jurors? I mean, why does only one of them get to talk about how they experienced it if we're going to base new trials on what the jury was thinking.
We can't, Justice Blacklock, and that's why that was abandoned as an argument for this appeal.
Yeah, if it's abandoned, then we won't address it, but I
Correct.
just have that question for you.
Sure.
Why should we be comfortable with that? And why wouldn't we want all 12 jurors to have a chance to tell us what they thought if we're going to go behind that curtain and allow their views of what happened to generate a new trial?
We should be uncomfortable with that because it just basically becomes a second trial. You know, what happened in the jury room. And this court's never advocated for that, you know.
But if the only juror we've heard from is the one who sees it the way the one saw it,
Yeah.
then we're not hearing from the other 11. We don't know what they thought. We have no basis. What really happened? Was this just a disgruntled juror, or, you know?
You're not talking about the question that came out. You're talking about.
I'm talking about afterwards.
Right. No, I mean, I don't think that we can even look at that, honestly. I don't think this court.
But the judge did. I mean, so you can abandon it as a ground, but that was the causal link in why we got the new trial order.
I disagree that that's the causal link. I agree that she heard that information, but that is not included in the grounds for her new trial.
Yeah, it's not, I guess it's not listed as one of the 7 paragraphs, but isn't it pretty clear from the record that that motivated the proceedings altogether and to generate the new order?
I would disagree with that conceptually. I think the judge would have recognized that that would be improper to consider that. I see I have 8 seconds left. If they have any further questions. If not, we appreciate the court's time and ask that the petition for writ of mandamus be denied and that the new trial order be upheld.
Thank you, Ms. Tippett.
Thank you.
Ms. Robertson, you have 5 minutes.
We're not asking the court to expand this beyond somewhere that has never gone. And it goes back to my argument from opening that this isn't about whether you have a loss of chance instruction in an injury case or a death case. It's whether you have the evidence from Kramer, whether your expert says you have such a bad injury or cancer or a disease or whatever that you were not going to survive even at the time the defendant, you say the defendant was negligent. If you have that evidence, Kramer and the progeny say you're entitled to get that instruction. That's what the court held in Hawley. And Hawley's not that different from this case, in all honesty. Yes, it was a cancer case. Yes, it was a death case. But the allegations in that case were just like the ones in this case because Alice Hawley, she alleged that the hospital failed to get the path report that had the cancer diagnosis to her doctor sooner, quicker, so he could start the treatment sooner. So 10 months went by. In this case, and the plaintiff said that's what caused her to die sooner from cancer. In this case, the plaintiffs were alleging that Dr. LaPuerta failed to diagnose the osteomyelitis in the finger on July 11th, and by not treating it, that it led to the whole finger being gone instead of maybe just part of it. So it's not that different from Hawley. And this court noted in that opinion that at the time of trial, Alice was still alive. They kind of even questioned why the parties were talking about chance of survival.
Just before you sat down earlier, you said that it should potentially be, this kind of instruction should be applicable in any kind of case. And now maybe I hear you saying, well, it needs to be a really serious injury. So we've heard, death only on the spectrum of the kinds of injuries where one might consider applying this death only, amputation of a digit. We've heard an example about loss of vision. What about, you think it should be applicable in all of those, I guess?
I don't know.
You would request it. What about sort of an example on the other end of the spectrum, like loss of a tooth? If someone comes into the dentist with a broken tooth and a piece is chipped off, and then ends up losing the entire tooth, does that qualify?
I don't know if
can you offer a limiting principle?
Yes, I think it depends on the expert testimony, because I don't know that you'll be able to get an expert to say in a broken tooth case that this was such a severe injury that no matter what the dentist did, the tooth was not going to survive. Maybe, but I feel like it all kind of goes to whether your experts testify to the percentages and things, that is what Kramer said. Because what Kramer said was, when there's evidence of that you have a less than 50% chance of surviving the injury regardless of what the defendant did, you can't recover. That's what the court said. So I think it doesn't really matter what kind of case it is. And then just briefly on the...
That's pretty expensive for a tooth, to have experts come in and,
Right.
and do all of that over, a partial or a whole tooth, but you think that's what's required?
I mean, I do think that's what triggers the loss of chance analysis. I mean, because otherwise it's just regular proximate cause, right? If there's no one saying that the defendant shouldn't be liable because in this case, like, for example, Dr. Rinsemer is the infectious disease specialist. He's the only infectious disease specialist. He says that even if Dr. LaPuerta had been giving IV antibiotics from day one, the whole course, that Mr. Torres was still going to lose that finger because of the severe compromise of the circulation. So, I mean, and then there's several other that actually used a percentage, 10%, 20%. So I do think it kind of depends on the testimony that you get, whether you get this instruction or not. I do think the testimony was in the record here. And the other thing I wanted to just real quick say is that the evidence was conflicting, so doesn't the jury get to decide? Isn't that the fundamental principle? Is that they get to decide whether to believe the plaintiff's expert, the defendant's expert, how much weight to give the testimony, all those things. And so the judge couldn't just go back in and say, I disagree. I think that jury instruction was confusing, so I'm going to reverse this duly deliberated verdict. In the Rudolph case, the court said you can't do that unless you have valid reasons. So that's why we've been challenging all the reasons.
If it would a valid reason be, look, I'm the judge, I was sitting there, I gave the instruction, bad on me, but if I was in the jury room, I wouldn't have known what I was being asked to decide.
That'd be great if that was in the record, but it's not in the record.
But would it be a valid reason if it were? I'm not saying that it is, but...
I guess it also kind of depends on what the jury problem is, because I think in the Rudolph case, there was an irreconcilable jury question problem, and the opinion says the judge can take a step back regardless of whatever objections were made and say, these don't reconcile, so I'm not going to render the judgment. But when there's absolutely no information other than inadmissible information about why the jury was confused.
No, it's just the judge. Like, I've been a judge for a long time. I must have just been having a bad day. I gave this instruction. If I were in the jury room, I wouldn't know what I had asked myself to decide. Now, we gave an answer. They all wanted to go home for Thanksgiving or whatever. They generate an answer, but I have no confidence in it because I can't tell what it is that they thought they were answering, and that just makes me very uneasy about it. And so I'm willing to subject myself to another trial as the trial judge. Is that a valid reason or not?
I mean, I hate to say that, concede that's a valid reason, but that would be better than what we have in this case.
I agree it's not what we seem to have here, but I mean, we're not saying that new trials are never can be granted when a judge in the judge's discretion can say something honestly like that, right?
Right.
Or are we?
And I know it's not admissible, but even that juror, the dissenting juror, he wrote in there that everyone agreed that the whole finger was not going to survive. I mean, so the judge saw all of that, and I know it's probably hard to get that out of your head, but you can't consider that. You have to go back and just remember what happened at the trial, what was said at the charge conference, and when the jury asked the note. I mean, the proceedings after the jury brought the note out was one page. There was just not a lot of discussion about it. So there's no insight as to why, what the judge thought about that.
So if a judge were to say that, then the appellate court could presumably look at stuff that and say, well, no, this is if it was just a pattern jury charge, if there's, it's perfectly clear as a matter of law, then that would be a basis to overrule the new trial grant. But it's not inherently something that's off limits for a trial judge. That's all I'm asking.
I don't think it's inherently off limits, because this court has said in some of its opinions about how judges are the ones who are sitting there, they hear everything, and so sometimes they have to make that call.
Right.
Any further questions? Thank you, Ms. Robertson.
Thank
you to
you.
all counsel. The case is submitted, and the court will take another brief recess.
All rise.